Hello and welcome to our Preventing Harassment, Sexual Assault, and Discrimination seminar. My name is April Lammers and I will be doing the training today. Let's get started. This is the contact information for bully, the Bureau of Labor and Industries. This is who you would contact if you had a problem and your employer was unable to resolve it. So Oregon law requires this training, and they've laid out some specifics of what they would like covered. This is a required employee training. Professional training is required to be provided to all managers, supervisors, and workers as follows. At least once during the year in which the contractor is first licensed. For new employees within 90 days of the date of hire. For existing employees who transfer or are reassigned into a new job providing janitorial services within 90 days of transfer or reassignment, and at least once every 2 years after the renewal of the license. So our goals for this training are as follows. We want to understand and prevent sexual assault, sexual harassment, and discrimination in the workplace. We want to develop cultural competency in the workplace, highlight protections for employees who report violations of law, describe civil rights protections under state and federal law, emphasize an employer's duty to protect employees from assault and harassment. We are going to be covering 11 points. And we are going to start with the definitions of sexual assault, harassment, and discrimination in the workplace. So what is sexual assault? To put it into simple terms without getting too graphic, it's any type of sexual activity that you do not consent to. Sexual harassment is unwanted sexual advances. The Oxford Dictionary defines it as behavior characterized by the making of unwelcome and inappropriate sexual remarks or physical advances in a workplace or other professional or social situation. Sexual harassment does not just refer to harassment that is sexual in nature, but also harassment that occurs because of a person's gender. Certain behaviors may be considered sexual harassment if they create a hostile and offensive work environment or if they intimidate the employee victim. These behaviors could be offensive jokes, inappropriate touching, or pressuring a person to engage in a sexual relationship. Sexual harassment is a serious problem, and it does not only victimize women. Men are also victims of sexual harassment in the workplace. So sexual harassment is not just physical, it can be physical, verbal, or visual. All harassment is not necessarily sexual in nature. There are two kinds of harassment defined in the laws. First one we're going to talk about is quid pro quo. Quid pro quo sexual harassment literally means this for that. And using this form, an employer or superior may pressure an employee into doing something they would not normally do in order to get promotions or to gain favor. The other kind of harassment is a hostile work environment. Hostile workplace harassment warning signs are unwelcome verbal or physical conduct. It's offensive in nature. Workplace behavior may be harassment if it's perceived to make the workplace a hostile environment. This can be physical, verbal, or visual. Just being rude isn't automatically harassment. But if a behavior makes a person feel intimidated, threatened, or offended, the law may see it as unlawful harassment. Some examples of unlawful harassment might be telling off-color jokes, hanging suggestive calendars, calling names, teasing a person because of their religion or appearance, and physically touching a person. Whether or not any of these things constitute harassment is subjective to how the victim perceives the behavior. When is it unlawful harassment? The standard for determining whether harassment is sufficiently severe or pervasive to create a hostile, intimidating, or offensive working environment is whether a reasonable person that was in the circumstances of the complaining individual would think that it was harassment. When determining whether a behavior is in fact unlawful harassment, the courts seek to find out if the behavior is severe or pervasive enough. And what exactly does constitute severe or pervasive? So generally, rude or annoying behavior by itself is insufficient to meet the severe or pervasive test. In determining whether acts are severe or pervasive, courts look at frequency, how often it happens, whether it's physically threatening or humiliating, or a mere offensive utterance, and whether it's actually interfered with a person's work. Isolated instances of poor behavior, unless they're extremely serious, are not sufficiently severe or pervasive. So I'm going to define those terms really quick. So severe would be harsh, unnecessarily extreme, and pervasive would be spreading widely throughout an area or a group of people, especially of an unwelcome influence or physical effect. So it's typically a repeated offense that's not dealt with. A one-time offense may be found to be unlawful harassment if it's severe enough. But just joking around with a person is not necessarily harassment. Harassment becomes unlawful where enduring the offensive conduct becomes a condition of continued employment, or the conduct is severe or pervasive enough to create a work environment that a reasonable person would consider intimidating, hostile, or abusive. Harassment is not only sexual in nature. It can be due to a variety of things, such as a person's religious beliefs, gender, or race. It is a common misunderstanding that harassment is only unlawful when it's sexual harassment. Unlawful harassment and discrimination may arise because of an employee's membership in any protected classification. Okay, let's look at another term, cultural competency. What is cultural competency? It's the ability to communicate effectively and appropriately with people of other cultures. It helps to ensure that the needs of all members of the community are addressed. It's an ongoing learning process aimed at integration and transformation of knowledge about individuals and groups of people into standards, attitudes, policies, and practices that enable them to work effectively together. So it's basically respecting everyone you work with, having an attitude of respect in the workplace, even if they are different than you, they're a different religion, being able to treat them with dignity and respect. This is the definition from businessdictionary.com. A set of behaviors, policies, and attitudes which form a system or agency which allows cross-cultural groups to effectively work professionally in situations. This includes human behaviors, languages, communications, actions, values, religious beliefs, social groups, and ethnic perceptions. Individuals are competent to function on their own and within an organization where multicultural situations will be present. So what does this look like in the workplace? Cultural competence would be understanding and respecting a person's personal beliefs and convictions, even if they are not necessarily what you believe or what you would do. So what is discrimination? According to the law, to discriminate means to make a distinction between individuals or groups based on common characteristics, real or perceived. Not all discrimination is unlawful. Discrimination is against the law when employers make decisions because an individual is a member of a class protected by state or federal civil rights statutes, so because of their being in that protected class. Unlawful discrimination is a form of harassment. Discrimination in the workplace takes place when an employer discriminates against an employee in relation to work-related decisions, so like hiring, firing, promotions, and availability of benefits. There are state and federal laws in place to protect against discrimination. The dictionary defines discrimination in the workplace as the discrimination in favor of or against an employee based on a group, category, or class to which the individual belongs, rather than on individual merit. According to federal and state law, it is illegal for an employer to treat a person unequally based on his or her race, gender, ethnicity, age, religion, or disability. Let's look at some state and federal civil rights protections that are in place. So, the Civil Rights Act of 1964 is a federal law, and it pertains to employers of 15 or more employees, except where noted. But Oregon's law is a little more narrow, and it pertains to employers of one or more employee, except where noted. And as you can see, race, color, national origin, sex, religion, retaliation, And there are several others listed. This is not an exhaustive list. And Oregon protections, this is also a partial list of protections under Oregon law. These are protected classes. Okay, and an employer is not allowed to discriminate against a person because of their belonging to this class, either in hiring them, firing them, promoting them, pretty much anything pertaining to their employment. So now that we've defined sexual assault, sexual harassment, and discrimination in the workplace, let's take a look at some ways we can prevent it. We should strive to be proactive and lead by example. We should communicate standards to all our employees, let them know what's expected of them, let them know what our company policy is on harassment and assault and discrimination. We should train all employees, which is why we're doing this training, and we should train managers and supervisors because managers and supervisors are supposed to be the leaders, and they need to lead by example and be a good example to all those who work with them. Managers and supervisors set the tone. They should resist the urge to join the harassment party. They should not turn a blind eye or a deaf ear to comments, jokes, or symbols of harassment and discrimination, and they need to have the difficult conversations. So if you are a person that's in a place of authority, a manager or supervisor, you need to be watchful and listening for instances of harassment or discrimination that you hear, and you need to say something. It could come back on you as a superior if you don't say something and the victim ends up going to the law over it. But communicating standards. The employer should develop a comprehensive written policy. We do have a written policy. Should include definitions and examples. Include examples of protected classes, including but not limited to, and add language like, and any other class of persons protected by local, state, or federal laws, rules, or regulations. And provide multiple avenues to report. So either to a direct supervisor, any member of the management team, human resources, and the company president. And you should include anti-retaliation provisions. So why have trainings? Having trainings can help us understand the laws, the definitions of words, and our avenues of dealing with discrimination and harassment in the workplace, such as, what is our company policy? Who do I go to with complaints? What can happen to me if I file a complaint? What can happen to me if I'm the offender? We train managers and supervisors. We conduct training on general principles of workplace harassment. We explain procedures for responding to complaints. Emphasize all complaints must be taken seriously. Every single complaint must be considered to be a serious complaint until it's fully investigated. When appropriate, we should require managers to involve the HR department, in-house, or outside counsel. Trainings also let supervisors and managers know they are held to a higher standard, since they hold a place of authority, and that they may even be liable for damages in a court case if it's found that they knew about an unlawful act and did not take sufficient action. So, what is sufficient action? A manager or supervisor should, if someone comes to you and they have a complaint, and you're a supervisor or manager, you should promptly investigate all alleged instances of harassment, even if a formal complaint is not filed. Take immediate and appropriate corrective action, which may include termination. A manager or supervisor do not retaliate, so don't try to get back at the person who complained. Do not permit other people to retaliate against them. And make sure you let your other managers and supervisors know not to retaliate also. So prevention is the best course of action. A great general rule and protecting factor to prevent sexual harassment and discrimination in the workplace would be to strive to treat all people with respect. Do unto others as we would want them to do unto us. We should treat others as we want to be treated. Imagine if everyone followed this one simple rule. If they did that, we wouldn't even need this training. But since everyone does not follow that rule, and sometimes harassment does happen, when it happens, what do we do? Any complaint that an employee has can be submitted either in writing or in person to Philip, Posey, or myself. And I promise that each complaint will be honestly dealt with. Our sexual harassment assault policy is zero tolerance. It is never, ever supposed to happen. And any complaints or accusations will be taken very seriously. Immediate and appropriate action will be taken. An employer is liable for harassment when the employer knew or should have known of the conduct, unless the employer took immediate and appropriate corrective action. An employer may be liable when an employee is harassed by supervisors, co-workers, agents, and even non-employees in the workplace. So if you are at a janitorial contract and one of their employees is harassing you, you still need to let your employer know so that we can do something about it. Bully and the courts will consider the extent of legal responsibility and control over the non-employee. What if you experience harassment? What do you do? Take notes and document what you see. Preserve any physical or documentary evidence. Check your company's policies and processes to see how to proceed. And then put it in writing. Make a written complaint to your supervisor, manager, or human resource department. And if you feel like your complaint is not being properly handled, then you can contact the Civil Rights Division at 971-673-0764. You do not need to be afraid of coming forward. There are protections put into place by the government for whistleblowers. These protections include employees who are victims as well as employees who witness discrimination or assault. Both are equally protected, and any employee or employer who witnesses an offense is required to report it to the necessary persons. If you see a coworker experiencing harassment, unwelcome words, or touching, remember, the law protects victims and those who report unlawful conduct from retaliation, even if the allegations cannot be proved. Unreported conduct usually just gets worse over time. Opposition to harassment need only be based on reasonable and good faith belief. An individual is protected even if the investigation does not result in finding of discrimination or harassment. So what if a complaint has been made and an investigation shows evidence of an unlawful act being committed? When an investigation yields substantial evidence, management should take immediate and appropriate action to end harassment and prevent it from reoccurring. They should provide counseling and training in milder cases while outlining the consequences if it happens again. And they should take stronger action in more offensive cases and termination and or suspension in extreme situations. And then they should monitor the situation to ensure that there is no retaliation. Retaliation against a person reporting unlawful activity, whether they are the victim or not, and whether the activity is substantiated or not, is unlawful. And it is the supervisor or manager's responsibility to see that retaliation does not occur. The employer is responsible to take actions to protect their employees and to provide a work environment that is free from intimidation, insult, or ridicule based on race, color, religion, gender, or national origin. The employer can also be sued in state courts. Therefore, employers should take steps to prevent and deal with sexual and other types of harassment in the workplace. An employer may be held liable for harassment that affects employees in the workplace, as well as acts of managers, supervisors, employees, and even harassment by customers, suppliers, and others who do business with them. An employer must set a high standard and keep the standard themselves. So what have we learned? These are our discussion points. Rude treatment versus harassment. They're not the same. How the frequency of harassment affects liability. So is it severe and pervasive enough to constitute harassment? Would a reasonable person find it to be severe and pervasive enough? That's how the law looks at whether or not an activity is harassment. And what about when the target of teasing is not offended? And how about when a customer or supplier, vendor of the business is the harasser? So even if the target of teasing is not offended, that's not to say that someone else who is within hearing or around you would not be offended. So it's best not to engage in activities that anybody could find offensive in the workplace. And again, when a customer or supplier or a vendor of the business is the harasser, so if you're at a contract and a person who works for the contractor, for the employer, not your employer, is the offender, you still need to let your employer know, because your employer could still be liable if you let your employer know and they don't do anything about it. And at H&S, we appreciate each employee, and we do desire to provide them with a safe work environment as much as humanly possible. Okay, so this is just the Federal Civil Rights Act of 1964 that we talked about earlier. Unlawful employment practices. The employer practices: it shall be unlawful employment practices for an employer to fail or refuse to hire or to discharge any individual, or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin, or to limit, segregate, or classify his employees or applicants for employment in any way which would deprive or tend to deprive any individual of employment opportunities, or otherwise adversely affect his status as an employee because of such individual's race, color, religion, sex, or national origin. And then Oregon law. It is the policy of the state of Oregon that unlawful discrimination on the basis of race, color, religion, sex, sexual orientation, national origin, marital status, age, disability, and other classes protected under Oregon statutes is a matter of state concern, and that such discrimination threatens individual rights and privileges and menaces the institutions and foundations of a free democratic state. And then there's some prohibited discrimination is a basis of unlawful practices and unlawful employment practices described in ORS Chapter 659A and other chapters of the Oregon statutes. And finally, again, we have the contact information for bully. And I will include in your copy of our policy the contact information for Philip, Posey, and myself if you have a complaint. And again, you can submit it in writing or in person. You don't have to come in person if you're uncomfortable doing so. You can submit it in writing and let your employer know what's going on if you have a problem. And we will deal with it thoroughly, completely and thoroughly. Thank you for your time.